Hi everyone. Okay, this is our part 2 lesson on IT legal responsibilities. We're continuing on. In this lesson, of course, we're talking about demonstrating the understanding of legal responsibilities in relation to information technology and describing an illegal use of information technology. In this particular lesson, we are also describing the legal concepts that are related to intellectual property, starting with copyright. Copyright is defined as the exclusive legal right given to an originator or an assignee to print, publish, perform, or record creative materials. It can be used to authorize other people to use the material. A copyright typically lasts for the life of the original author plus 70 years. But in cases of copyright work that is owned by a publisher or another third party, the protection lasts for 95 years from the original creation date. Copyright is obtained by the simple act of creating the original work. When an author writes down an essay, creates a song, designs a program, he or she automatically has the copyright. Copyright can also be obtained by a registration in the U.S. Copyright Office. And if you're using that work commercially, it is advisable to register for a copyright. Because if you are bringing legal action against someone who has used a work without permission, you must have a registered copyright in order to take that legal action. Now, copyright infringement occurs when a copyrighted work is reproduced, distributed, performed, publicly displayed, or made into a derivative work without the permission of the copyright owner. That's straight from the U.S. Copyright Office. Copyright infringement will result in serious penalties, such as criminal fines, where you can be charged up to $250,000 for each offense committed. You could also get prison time. First-time offenders can serve up to 5 years in prison, while repeat violators can face an additional 10 years. Okay, let's move on to trademarks. Now, trademarks are a symbol which identifies a particular source of goods or service from others. This could be a word, a phrase, a logo, a shape, or a sound. And some examples include the Nike swoosh, the Facebook F, or Apple's apple with a bite mark. Trademarks have two basic types. There's the common law trademark, where you see a TM. This is a trademark that automatically is received by an organization when a symbol is consistently being used in the normal course of that business. There's also a registered trademark. That's where you see an R with a little circle. This is a trademark which has been examined, approved, and registered with the Trademark Office. Now, trademark infringement is the unauthorized use of a trademark in a manner which is likely to cause confusion, deception, or mistake about the source of the goods or services. And punishments for trademark infringement may include the following, like a court order notifying the defendant to stop using the accused mark. This is kind of like a cease and desist order. You could have monetary relief, including the defendant's profits, any damages sustained by the plaintiff, and the cost of the action. You can also get compensation made to the plaintiff's attorney's fees. Next is a patent. This is a government license which gives the holder exclusive rights to make, use, or sell an invention for a designated period of time. It's a form of intellectual property protection which prevents the invention from being infringed or used by others. It usually lasts for 20 years in the United States. Now, a patent is not automatically granted when someone has an invention or an idea. You must apply for a patent through the government patent office, and it will only be granted if the invention or the idea meets certain conditions. It must be original, it must be non-obvious, and it must be useful. Now, patent infringement is the use of a patented invention without permission from the patent holder, and it can occur in different ways. There's direct infringement, which occurs when a patented product is manufactured without permission. There's also indirect infringement, which is encouraging or aiding another in infringing a patent. And there's contributory infringement, which occurs when a party supplies an infringer with a part which has no substantial non-infringing use. Patent infringement can result in serious consequences. The infringer must pay damages to the patent holder, including lost profits that the patent holder would have realized without the infringement, any reasonable royalty for the unauthorized use, And the prevailing party is also entitled to costs, including court filing fees and related litigation expenses. Next are trade secrets. This is information that gives a business a competitive edge. It's also known as confidential information, and some examples can be computer algorithms, customer lists, survey results, soda formulas, patterns, methods, and practices that the business uses. Trade secrets are defined differently based on the jurisdiction, but they have these common characteristics. It is not public information, it provides an economic benefit to the holder, and its secrecy is actively protected. It is important to note that if the holder of the trade secret fails to safeguard the secret, or the secret is independently discovered, or becomes general knowledge, then the protection of the secret is removed. Now, trade secrets are protected by the Economic Espionage Act of 1996 and the Defend Trade Secrets Act of 2016. Now, this act allows the owner to sue in federal court if the trade secret is misappropriated. Now, federal law defines trade secrets as all forms and types of the following: financial, business, scientific, technical, economic, engineering, and it also includes whether the trade secret is tangible or intangible, and where and how the trade secret is stored, whether it be physically, electronically, or graphically. So that concludes this first part lesson on intellectual property. And in the next lesson, we are going to continue to describe the legal concepts related to intellectual property.